This module is No Contact Orders and Emergency Removals. I'm Adam Wolkoff, an Assistant Director of the Student Conduct Institute. Both federal law and some state laws, like New York's Education Law 129B, require colleges and universities to provide no contact orders to students pending the outcome of a disciplinary process arising from sexual and interpersonal violence.
Under the Title IX final rules, which were issued in final form on May 19, 2020, schools may also issue an emergency removal of a person where there is an immediate threat to the physical health or safety of any student or other individual arising from the allegations of sexual harassment. We will highlight both legal requirements and best practices, and we look at some cases where courts have drawn lines where the restrictions have gone too far or not far enough.
This module has 3 learning objectives. We will cover both no contact orders and emergency removals, learning their purpose and scope. As you're likely aware, these restrictions of contact apply to areas within the campus's jurisdiction and are enforced by the institution itself. If the parties seek restrictions of contact beyond your campus's jurisdiction, they will need to look to the civil and criminal courts for orders of protection that apply beyond the campus. Then, we will review the legal requirements for each type of restriction. In both cases, New York law and traditional standards of due process require a meaningful opportunity for the parties to review the restrictions. We'll go over that New York mandated process in detail. Even if your campus is not governed by New York law, we believe that the 129B process is a best practice, as it protects the constitutional rights of the parties while ensuring the equal access to education guaranteed under Title IX. Finally, we will look at the enforcement of restrictions of contact. Institutions have a Title IX obligation to protect the parties from further harassment once an incident of sexual misconduct is reported. An institution's failure to apply a restriction of contact or enforce it may trigger Title IX liability, under the theory that the institution has acted in deliberate indifference to the parties' needs by failing to take these urgent measures. During this module, I'll refer to the party who is subject to the restriction of contact as the restricted party. The person who is being protected under the restriction of contact is the protected party. After receiving a sexual misconduct complaint, institutions commonly order the accuser and accused to avoid each other throughout the disciplinary proceeding. Under a no contact or stay away order, the parties must avoid any intentional contact, both in person, electronically, and by phone. A no contact order is not a sanction. It's an administrative measure taken to maintain the status quo and avoid further harassment or violence. The scope of the no contact order should be tailored to best fit the circumstances. Whenever possible, it should be limited in time and place so that both parties can continue to pursue their education with minimal interference by the other. They can be designed with the schedule so that both parties can access the same facilities or class buildings, but at different times or days of the week. They must be limited to the time period pending the final determination of the disciplinary process. Certainly, at the end of the disciplinary process, a permanent no-contact order may be put in place, but that is different than the no-contact orders we are discussing in this module, which are designed to prevent ongoing contact between the parties before the end of the disciplinary process. Under federal law, no-contact orders can be mutual. Title IX does not prevent an institution from imposing a mutual no-contact order, which would put the burden on both parties to avoid intentional contact with one another. You can click on the blue question mark to read more. In 2018, a federal district court in Massachusetts held in Leader v. Harvard College that mutual no-contact orders are not evidence of deliberate indifference to the reporting individual's situation, even if they put a burden on the reporting individual to avoid the respondent. New York imposes a slightly different requirement than Title IX. New York's Enough is Enough Act, Article 129B, Section 6444, 4C, requires institutions to advise the accused that the responsibility to stay away falls on the person restricted by the order and not on the protected party. According to the New York State Education Department's guidance on Article 129B, if the restricted person and protected person are in the same place accidentally, it's incumbent upon the restricted person to remove themselves in a reasonable time and manner. They need not run or make a scene out of leaving, but they should leave the location. What if the protected person is actively seeking to be in the same place as the restricted person? Under that rare case, the institution is not obliged to sanction the restricted person and may take other reasonable measures to address the situation. Briefly, let's discuss what a campus must do when applying a no-contact order. The institution's role is to develop an appropriate no-contact order, which may include a schedule of attendance in certain locations, such as academic buildings, libraries, athletics or fitness facilities, and dining halls. The school must explain its terms to the parties and adjudicate any disputes about the scope of the order through the process, which we will discuss in subsequent slides. And the institution must ensure that campus security enforces the order. Accused individuals who violate the order may be subject to further conduct charges. The basic requirement here is notice. The person restricted by the no-contact order, along with the protected party, must be given notice of the order. As always, we advise electronic service of a written notice through the student's official campus email account, in addition to any other form of notice you may use. The parties must also have an opportunity to be heard on the order through a review process we will discuss in a few minutes. What if the no-contact order arises in an emergency situation? If the institution believes that the accused person poses a threat to the reporting individual or the campus community, it may impose a no-contact order without notice to the accused. Once the order is in place, the restricted person must receive notice of the terms of the no-contact order and be given an opportunity to be heard on the order. When an institution issues a no-contact order, the subject of the order is entitled to rudimentary procedural safeguards. Unlike an expulsion or long-term suspension, a no-contact order does not implicate a substantial property or liberty interest in the restricted person's education or reputation. So, as a federal district court in Massachusetts wrote in 2018 in the Haydick case against the University of Massachusetts at Amherst, a face-to-face meeting is an adequate means for the restricted person to challenge a no-contact order. New York state law provides a helpful framework for settling disputes that arise out of no-contact orders. Under Section 6444, subsection 4A of the Education Law, Article 129B, both parties must be afforded a prompt review, reasonable under the circumstances, of the need for and the terms of the no-contact order, including potential modification, and they shall be allowed to submit evidence in support of their request. The law does not require a formal hearing to adjudicate these issues. It does require the opportunity to submit evidence regarding the need for a modification. No-contact orders must be appropriate in their scope and duration, or they may amount to a due process violation. In New York, for example, a trial judge in Nassau County ruled in the 2018 case of Hall v. Hofstra that a no-contact order could not be for a potentially unlimited duration, but should be designed to limit contact for the time period before the final determination on the underlying contact matter. A no-contact order could be imposed after a final determination, but that decision would depend on the outcome of the conduct process. The point of a pre-decision no-contact order is to separate the parties so that there is no further creation of a hostile environment. The Hall Court also made clear that a no-contact order may need to be adjusted to meet changing circumstances. In that case, a respondent was subject to a no-contact order that seriously restricted his ability to use campus facilities. Yet the reporting individual was not actually on campus for much of the time, but on a study abroad trip. Moreover, the reporting individual was not pursuing charges for much of this time either, putting the respondent in limbo concerning his ability to access the campus without an opportunity to clear his name. Those circumstances raised a due process red flag. The no-contact order should also be sufficient in scope to protect the Title IX rights of reporting individuals. Take the 2017 case of Doe v. Motlow State, decided by a federal district court in Tennessee. There, a university did not require a respondent who had been suspended from his basketball team from avoiding a basketball practice facility under a no-contact order. This presented a risk of ongoing harassment to the reporting individual, who was a student athlete and had to spend significant time in the athletic facility. The reporting individual was not simply claiming the possibility that she would encounter the respondent somewhere on campus, but showed that she was actually seeing him for extended periods of time at a practice facility she was required to use. A different situation might arise where the reporting individual only has a limited connection to that athletic facility. For example, in Rayhan v. George Washington University from 2018, a federal district court in the District of Columbia held that a university did not act in deliberate indifference to a reporting individual when it failed to implement a no-contact order against a respondent found responsible for sexual assault and allowed the respondent to continue working at a campus gym. Even though the reporting individual was effectively denied access to the gym because of the respondent's employment for a few weeks before her graduation, and the reporting individual encountered the respondent once, those allegations, standing alone, were not sufficiently severe, pervasive, and objectively offensive to constitute deliberate indifference. Another critical consideration is whether the no-contact order is so wide-ranging that the restricted student cannot adequately prepare for the disciplinary hearing. In one case, the 2018 decision of Doe v. Marymount University, a Virginia federal court allowed a respondent to move forward on a Title IX claim where he alleged that the university prevented him from contacting witnesses on his own behalf as a term of the no-contact order. If the respondent could not meet with witnesses, then he lost a chance to meaningfully respond to charges, which presented a due process issue. One of the core functions of no-contact orders is to protect reporting individuals or other parties from exposure to further harassment. This requirement demands both the implementation of no-contact orders and their effective enforcement. Failure to enforce no-contact orders can subject an institution to Title IX liability under the theory that they've offered a reporting individual a clearly unreasonable response to sexual harassment or violence. Also, under the Clery Act, accommodations must be provided to reporting individuals if they are requested and reasonably available. A failure to provide or enforce a no-contact order could run afoul of this requirement. Proving that an institution acted clearly unreasonably in response to a report of sexual harassment or violence is very hard under the high standards set by the U.S. Supreme Court. As a result, we have many published decisions suggesting that violations of a no-contact order will not make an institution liable to protected individuals under Title IX. This case law describes minimal standards applicable to Title IX lawsuits, and it's not an indication of best practice or potential OCR expectations in the event of a federal investigation. Still, it's important to understand that sporadic encounters between the restricted person and the protected party are usually not Title IX violations, nor are occasional glimpses between those parties or contact not resulting in speaking or touching. If the institution is not aware of violations of the no-contact order, then it likely will not be held responsible under Title IX for those violations. Likewise, if the violations occur outside the institution's jurisdiction, like in an off-campus apartment, they are unlikely to trigger liability. In the few published cases where violations of a no-contact order lead to potential Title IX liability, the institution knows of frequent interactions and ongoing harassment and fails to stop it. So, a reporting individual could not have equal access to educational opportunities, for instance, if she had to deal with frequent interactions with the person she believed raped her. So in Cavalier v. Catholic University, a 2018 case from the Federal District Court of the District of Columbia, the reporting individual alleged these encounters occurred about once every 2 weeks during her freshman year, twice a week during her sophomore year, and once a month during her junior and senior years, and involved the respondent and his friends calling her sexually derogatory slurs. Although she reported these violations at least 6 times, the administration did not change its approach to enforcing the no-contact order, and even allegedly housed the respondent 200 feet from the reporting individual during one semester. Notably, when that case was brought to the summary judgment stage, the court dismissed the portion of the Title IX claim based on that no-contact order issue. The court found that the university had followed its own procedures properly when enforcing the no-contact order, and therefore a reasonable jury could not find that the university was deliberately indifferent to violations of the order. A long delay in issuing a no-contact order, coupled by evidence of further harassment, may also be grounds for finding deliberate indifference. In Tackett v. University of Kansas from 2017, the reporting individual alleged that the university did not issue a no-contact order against the respondent for several months until the reporting individual actually sent a letter demanding this accommodation, and that the reporting individual encountered the respondent more than once, including an occasion where the respondent, quote, stared her down and called her a derogatory name. If proven, this could amount to a Title IX violation. Now let's move on to a more substantial form of restriction of contact, an emergency removal. Before the issuance of the Title IX final rule, colleges and universities commonly issued interim suspensions of individuals pending the outcome of a disciplinary process, protect the safety of the protected party and the campus community. Now, the final rule expressly prohibits the use of interim suspensions against students who are respondents. The Department of Education explains that a suspension, even a temporary one, is a form of disciplinary sanction. Because a disciplinary sanction can only result from the grievance process it mandates under the final rule, no disciplinary sanction can be issued before the process is final. So interim suspensions are out as a formal matter, and any policies allowing for interim suspensions in Title IX cases have to be changed. But colleges still have a mechanism for removing individuals who pose a safety risk to the campus community. The final rules call this process an emergency removal, and as a practical matter, it will largely conform to most colleges' existing practices concerning interim suspensions. The main difference may be that an interim suspension is always tied to the grievance process itself. It is interim, meaning that it can only last as long as the process. Once the process ends, the student is either reinstated, or the suspension may continue or become a permanent expulsion. By contrast, an emergency removal has no specific time restriction. It is tied to the danger itself, and in theory may last as long as necessary to handle the threat. Section 106.44c of the final rules provides that a person may be removed on an emergency basis whether the grievance process is underway or not, but there has to be an emergency arising from conduct that could constitute sexual harassment as defined under the final rules. So this could include both sexual violence and severe, pervasive, and objectively offensive sexual harassment, and the college may evaluate both the substance of the sexual harassment and any post-incident behavior manifesting a threat. Keep in mind that this module is only covering emergency removals stemming from Title IX misconduct. If your policies allow for interim suspensions for other threats, such as a student bringing a gun to school, that can be handled through a separate process. The final rules outline a 5-step process surrounding the issuance of an emergency removal. First, the campus must conduct a prompt, individualized safety and risk analysis. The final rules don't offer a specific template for doing this analysis, and your existing protocols may already satisfy this requirement. There are no specific rules regarding what type or volume of evidence is needed to support the risk assessment, who must do the assessment, or how quickly it must be done, although it needs to be prompt in light of the circumstances, and can't be done by someone with a conflict of interest or bias. Keep in mind that whoever participates in the risk assessment may be conflicted out of further involvement in the grievance process. Whatever process you use, it must be individualized, focusing on the specific respondent and the specific circumstances arising from the allegations of sexual harassment that pose an immediate threat to a person's physical health or safety. Next, the institution has to meet the statutory criteria. First, they must show that the respondent poses an immediate threat justifying removal. This is a case-by-case analysis, and institutions may consider the respondent's propensity, opportunity, and ability to effectuate a stated or potential threat, and the balance between the complainant's subjective fear of harm against an objective, reasonable person standard. The institution may also consider whether less restrictive means, such as a no-contact order, would address the concern. Second, the underlying threat has to be to the physical health or safety of a person. Emotional impacts, standing alone, are not enough to justify removal, and the Department of Education advises the use of supportive measures to address non-physical threats. But the line between physical and non-physical threats may be hard to distinguish, especially when it comes to forms of sexual harassment. Third, threats not arising from the allegations of sexual harassment could not be addressed through a Title IX emergency removal. But certainly, if a respondent threatened a complainant with physical violence after the filing of a complaint, that would fall under this section. So would a respondent's threats of self-harm after being accused of sexual harassment. Once the statutory criteria are met, Step 3 is to evaluate the applicability of disability law to the removal decision. As such, those who make the removal decision must have adequate training on the intersection between Title IX and various federal and state disability laws as applicable. Step 4 is to consider whether supportive measures may be more appropriate than an emergency removal in balancing the rights of the parties. The final rules require that all parties be afforded equal educational access, and require that schools not impose unreasonable burdens on any party to achieve that goal. It may be that the immediate threat of physical harm has passed, making the removal inappropriate. The department encourages the use of supportive measures whenever possible, which might include a no-contact order or a change in the party's housing or class schedules to limit the risk of further contact. Finally, Step 5 requires the opportunity for an immediate review. This review procedure appears to conform with existing law and practice. For example, under New York law, both the restricted party and protected party may seek prompt review, reasonable under the circumstances, of the need for and the terms of an interim suspension. Hearing formalities are not required, but the opportunity must offer a meaningful opportunity to present evidence to challenge the suspension or urge its continuation. While New York law addresses interim suspensions, it appears to satisfy the Title IX criteria for review, provided that prompt is interpreted to mean immediate. Case law governing the due process attendant to interim suspensions also appears to conform with the Title IX final rule. The leading case on this issue comes from the First Circuit Court of Appeals, which governs Massachusetts, Maine, New Hampshire, and Rhode Island, and will likely have persuasive authority elsewhere. This 2019 case, Haydak v. University of Massachusetts Amherst, holds that if there is no real exigency justifying a suspension without notice, and the institution wants to maintain a suspension for a lengthy period before a final determination, due process requires something more than an informal interview with an administrative authority of the college. In Haydak, the court ruled that the respondent did not have a sufficient opportunity to be heard on the interim suspension. The key issue in imposing an interim suspension is that continued contact between the parties posed a risk to campus safety. Yet the respondent had evidence that the contact was mutual and welcome. The respondent should have been afforded something more than an informal interview to present this information. While the respondent did admit to continued contact with the reporting individual, according to the court, had university officials conducted a more substantial hearing before suspending the respondent, they would likely have discovered that they misunderstood the nature of the contact between him and the reporting individual. As there was no emergency situation and ample time to provide the respondent with prior notice of the suspension and an opportunity to be heard, the court found a due process violation. While the emergency removal process is new, case law interpreting the interim suspension process shows that proper enforcement is a Title IX responsibility. A final slide on enforcement. Under Title IX, an institution may act in deliberate indifference of a reporting individual's rights when it fails to remove an accused person from campus who poses a danger to that person or the campus community. Institutions have flexibility in deciding whether to grant an interim suspension. A good faith decision not to impose one is unlikely to trigger Title IX liability. But if the institution identifies a continuing threat and imposes the suspension, its failure to enforce the suspension could amount to a Title IX violation. Thus, in a 2018 case from Ohio, Joyce v. Wright State, a reporting individual was able to move forward on a Title IX claim against her university, where she alleged that the university waited 3 days to respond to a rape allegation through a suspension, and then failed to enforce its order, despite the university's contention that there was no contact between the reporting individual and the respondent. In summary, restrictions of contact like no contact orders and interim suspensions are limited to campus, and therefore the narrow purpose of avoiding the creation of further hostility between the parties and maintaining the status quo until the outcome of the disciplinary process. In particular, interim suspensions should never be issued without a finding of a continuing threat to campus health and safety. With both types of restrictions of contact, we must ensure that procedures are available for all parties to challenge the scope of the restrictions.